Good afternoon, everyone. My name is Flavros, and I'm reporting right from my room. This is just me reading some articles for you, and today the topic of the day is Supreme Court rejects affirmative action programs at Harvard and U.N.C. In earlier decisions, the court had endorsed taking account of race as one factor among many to promote educational diversity. This has been written by Adam Liptak, reporting from Washington, June 29, 2023. The Supreme Court on Thursday rejected affirmative action at colleges and universities around the nation, declaring that the race-conscious admissions program at Harvard and the University of North Carolina were unlawful and sharply curtailing a policy that had long been a pillar of higher education. The vote was 6-3, with the court's liberal members in dissent. In quotations, the Harvard and U.N.C. admissions program cannot be reconciled with guarantees of equal protection clause. Chief Justice John G. Roberts, Jr. wrote, "For the majority, in quotations, both programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack of meaningful endpoints." End quote. Justice Sonia Sotomayor summarized her dissent for the bench, a rare move that signals profound disagreement, and said that affirmative action was crucial to countering persistent and systematic racial discrimination. In quotations, the court subverts the constitutional guarantee of equal protection by further entrenching racial inequality in education, the very foundation of our democratic government and pluralistic society, she said in her written dissent. That was unquote. The decision all but ensured that the student population at the campuses of elite institutions would become whiter and more Asian, and less Black and Latino. It was also expected to set off a scramble at schools revisit their admissions practices, and it could complicate diversity efforts elsewhere, narrowing the pipeline of highly educated, credentialed minority candidates and making it harder for employers to consider race in hiring. The ruling demonstrated that court's conservative supermajority has been moving to a brisk pace to take on some of the thorniest and most divisive issues in American society, including abortion, guns, and now race. All of the span of a year, it also reflected President Donald J. Trump's outsized imprint on the court after his appointment of 3 justices, renewing questions about whether the court's approach, which on Thursday upended more than 40 years of precedent, threatens the stability of the law and court's legitimacy. Public opinion polls offered a complicated picture of where people stand on affirmative action, and the numbers vary with low questions are phrased. But on balance, race-conscious admissions programs are unpopular, suggesting that Thursday's rulings will not give rise to backlash like the one that followed last year's decision eliminating a constitutional right to an abortion. Democrats, including President Biden, assailed the ruling as a step backward. In a televised address hours after it was handed down, Mr. Biden urged the country to make sure the decision was not, in quotations, the last word, quotation end, on affirmative action. In quotations, discrimination still exists in America, end quote. He said, repeating his words for emphasis, quote, today's decision does not change that, end quote. Mr. Biden paused as a reporter asked if the court was rogue. This is not a normal court, he responded. Conservative leaders and advocacy groups celebrated the outcome, with some saying it would make the admissions process more fair. Mr. Schlapp, the chairman of the American Conservative Union, one of the nation's largest conservative groups, said that the decision paired with the court's abortion rulings last year, in quotations, serve as a triumphant return to restoring our tattered Constitution, end quote. In dissent, Justice Sotomayor wrote that the majority had abandoned principled adjudication. In quotations, at bottom, she wrote, the 6 unelected members of today's majority upend the status quo based on their policy preferences about what race in America should be like, but is not, and their preferences for a veneer colorblindness in society where race has always mattered and continues to matter in fact and law, end quote. The Chief Justice wrote that admissions officers could sometimes still take account of race, including all the college essay, in quotations. Nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion. However, discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise, end quote, he wrote. The point, Chief Justice Roberts said, was that applications must be assessed individually, in quotations. In other words, he wrote, the student must be treated based on his or her experiences as an individual, not on the basis of race, end quote. Justice Sotomayor said that was thin gruel, in quotations. This supposed recognition that universities can in some situations consider race in application essays is nothing but an attempt to put lipstick on a pig, in quotation, she wrote. But she acknowledged that the majority had left colleges and universities with some tools to admit students of different backgrounds, notably by focusing on socioeconomic factors. The Chief Justice wrote that education, diversity, the idea that students of different backgrounds learn from one another is a commendable goal. But he added that such a goal resistance the demanding judicial scrutiny that is required when race is a factor because it cannot be measured. In dissent, Justice Sotomayor wrote that the majority had effectively jettisoned the rationale, just had justified affirmative action for decades. Without any new factual or legal justifications, she wrote, the court overrides its long-standing holding that diversity in higher education is of compelling value. To avoid public accountability for its choice, the courts seek cover behind a unique measurability requirements of its own creation, end quote. Justice Clarence Thomas, Samuel A. Alito, Jr., Neil M. Gorsuch, Brett M. Kavanaugh, and Amy Coney Barrett joined the Chief Justice majority's opinion. Justices Elena Kagan and Ketanji Brown Jackson joined Justice Sotomayor's dissent. In all, six justices issued opinions, collectively spanning more than 200 pages, notable from sometimes harsh language and starkly different accounts of the nation's history and the role race plays in contemporary society. Two sides, for instance, offered competing understandings of the meaning Brown v. Board of Education, the towering 1954 decision that bared racial segregation in public schools. The lesson of Brown, Chief Justice Roberts wrote, was that, quote, the time for making distinctions based on race has passed, end quote. Justice Sotomayor said the decision stood for a different principle and accused the majority of engaging in revisionist history. Quotations. Brown was, she wrote, a race-conscious decision that emphasized the importance of education in our society, end quote. She added, quote, at the risk of stating the blindly obvious, and as Brown recognized, the 14th Amendment was intended to undo the effects of a world where law systematically subordinated black people and created a racial caste system. Brown and its progeny recognized the need to take affirmative, race-conscious steps to eliminate that system, end quote. Justice Thomas Jackson, the court's black members, traded particularly sharp barbs. Quotation. As she sees things, Justice Thomas wrote of Justice Jackson, we are all inexorably trapped in a fundamentally racist society, with the origin of sin of slavery and historical subjugation of black Americans still determining our lives today. Justice Jackson responded that her colleagues, in quotation, prolonged attack respond to a dissent I did not write in order to assail an admissions program that is not the one U.N.C. has crafted, adding that, in quotations, Justin Thomas's opinion also demonstrates an obsession with race consciousness that far outstrips my or UNC's holistic understanding that race can be a factor that affects applicants' unique life experiences, end quote. She said she would not engage on every one of his points as, in quotations, Justice Thomas ignites too many more straw men to list or fully extinguish here, end quotation. Chief Justice Roberts in a footnote, limited the sweep of the decision in one respect, saying that the court was not deciding whether military academies may take account of race in their admissions decisions as they have potentially distinct interests, quotations. The sharp divisions were also evident in the courtroom where three justices spoke from the bench. Between Chief Justice Roberts' announcement of his majority opinion, Justice Sotomayor's oral dissent, Justice Thomas summarized his concurring opinion in his booming baritone He said he was compelled to address, in quotation, race-based discrimination against Asian American students, end quote, adding that, quote, such discrimination is plainly and boldly unconstitutional, end quote. Then Justice Sotomayor, seated directly to Justice Thomas's right, offered her dissent, speaking for almost 20 minutes. Quotations. In a society where opportunity is dispensed along racial lines, equality cannot be attained through race blindness, he said. Two cases decided Thursday were not identical, as public universities U.N.C. is bound by both Constitution's Equal Protection Clause, the Title VI of Civil Rights Acts of 1964, which bars race discrimination by institutions that receive federal money. Harvard, a private institution, is subject only to the statute. In North Carolina case, the plaintiff said the university discriminated against white and Asian applicants by giving preference to black, Hispanic, and Native American ones. The university responded that its admissions policy fostered educational diversity and were lawful under long-standing Supreme Court precedents. The case against Harvard has an additional element, accusing the university of discrimination against Asian American students by using a subjective standard to gauge traits like likability, courage, and kindness, and by effectively creating a ceiling for them on admissions. Lawyers for Harvard said that challengers had relied on flawed statistical analysis and denied that the university discriminated against Asian American applicants. More generally, they said race-conscious admissions policies were lawful. Both cases, Students for Fair Admissions v. Harvard, number 20-1199, and Students for Fair Admissions v. University of North Carolina, number 21-707, were brought by Students for Fair Admissions, a group founded by Edward Blum, a legal activist who has organized many lawsuits challenging race-conscious admissions policies and voting rights laws, several of which have reached the Supreme Court. The university both won in federal trial courts, and the decision in Harvard's favor was affirmed by federal appeals court. The key precedent was Grutter v. Bollinger, a 2003 decision in which the Supreme Court endorsed holistic admissions programs, saying it was permissible to consider race to achieve educational diversity. Writing for the majority in that case, Justice Sandra Day O'Connor said she expected that, in quotations, 25 years from now, in quotations, or in 2028, the use of racial preferences will no longer be necessary. Chief Justice Roberts wrote on Thursday that there is a reason to believe that respondents will, even acting in good faith, comply with Equal Protection Clause at any time soon. In his concurring opinion, Justice Thomas wrote that the majority of opinion, quotations, rightly makes clear that Grutter is, for all intents and purposes, overruled. Quotation end. For her part, Justice Sotomayor struck a defiant note, in quotations, the pursuit of racial diversity will go in, she wrote. Although the court has stripped out almost all uses of race in college admissions, universities can and should continue to use all available tools to meet society's need for diversity in education. Despite courts' unjustified exercise of power, the opinion today will serve only highlight the court's own impotence in the face of America who cries for equality resound. Thanks, everyone. I mean, that's a big article, I guess, that's huge, and my opinion on this is kind of the system is shooting itself in the foot, just like it has been for a long time. Like, okay, we want this, and once it starts working in that way, they're just like, okay, well, now we want this back again. Now we feel discriminated. Well, now we're discriminating against group. It's kind of just a never-ending battle that, will we win? Who knows? We can make everyone happy, kind of, but we're going to lose. We have to battle between what we're going to lose and what we're going to win as well. And so we're just kind of flip-flopping. Is the theme here is like, before we were saying, oh, these schools or these places don't have any colored people, and now we want more not colored people, which, you make sense of it. Have a good day.